He's in the same position, Your Honor. He wants to talk to family. There's also potential information regarding his co-defendant that he wants to potentially solidify with family as well, as far as the whereabouts of the co-defendant. I don't want to put that on record, but nonetheless, we might be able to negotiate something a little different if we're able to pinpoint the co-defendant. At least my conversations with Mr. Abadi.
That person's indicted, just a fugitive, or it is a Fanu-Lanu situation?
Indicted fugitive.
Okay.
Is my understanding of it.
I think that's right. I remember there being.
I remember looking at the indictment.
I'll look it up while we're waiting, but let's bring Mr. Chalmers out. We won't touch upon that second part of it. But let's just make sure we get on the record where we are and what the timing is out here. All right, let's get back on the record in Mr. Chalmers's case. We took a break for an hour plus. And as I understand it, Mr. Chalmers, during the break, Mr. Partridge, one, was able to speak with some of your family members, and then two, relay to you some of what they were thinking. And then three, most important, you have told Mr. Partridge you would like an opportunity to speak with those family members, which I think means going back to the jail and using the phone system there. Is that correct? Okay. Time is running short. I'm happy to give you that opportunity. If I look at tomorrow's schedule, I am stuck in a long motion in the morning, but in the afternoon, I've got a plea and arraignment calendar, which is pretty open. So maybe what we want to do as a default is have you brought over tomorrow. So we know you're coming over. That way you two can touch base, and why don't you plan, Mr. Partridge, on being here at the 1:30 calendar. And that way, Mr. Chalmers will be here before then. So if you want to show up before then and he's up, and we're in this courtroom tomorrow. So we'll be back here in 5D. Next week, we should be home. You guys can talk in advance, but at 1:30, I'll be looking to get an update from you and Mr. Rao, whether it's you or Mr. Hawkins, if someone from the DA's office, and you can zoom in, that's fine too. But if you get wind from Mr. Partridge that it's going to be a plea, then probably having one of you in person would be good. I don't know what your schedule's like.
I think that should be fine. I have to be in 4D in the morning, so I don't know how long that.
Okay, you may feel liberated when you get here, but
perhaps
if you are so liberated.
The only thing I would ask the court is, so there is a witness that lives in South Georgia that Mr. Hawkins and Mr. Brown are going down to drive to go see. And the only thing I would ask is if the court would consider, if it looks like, I don't want to put words in anyone's mouth, it seems like we're leaning towards a potential resolution short of trial. Given that they have to utilize resources to go down there, if the court wouldn't mind potentially moving this case from the next week's calendar, given, I guess, the position that a sexual assault unit finds itself in, ready for trial. Well, if we could just move that so that way I can tell Mr. Hawkins they don't have to go down to South Georgia to go interview this witness in preparation for a trial that may not in fact take place next week. I would just make that request to the court.
Okay, I hear you. This is the case we'll try if it's not a plea. And the other gentleman is on bond, the rape trial we've got. So it would be the backup to this one. Now, a plea would make this not a trial, or if we learn definitively that Mr. Partridge is going to trial on Monday in Clayton County on an older case, and it sounds like the case is older. I don't know how definitive it being a trial is, and I haven't engaged with Judge Malone at all. That would be another thing, but that we might not know before Mr. Hawkins and is it Mr. Brown?
Yes.
Mr. Brown would need to decide, are they driving to South Georgia? My counsel would be keep on getting ready. And then maybe you and Mr. Partridge can have an offline conversation that he can handicap it like it's 90% is working out. And then you guys gamble about not going to South Georgia. But I am going to keep this in my mind as first out on Monday. And the only two ways right now, as I see it coming off, would obviously be a plea, and it's not a trial, or we learn that we've lost Mr. Partridge because of the older case. All right, so Mr. Chalmers, the way we left it before the lunch break was that, well, how long is this offer open? Is it through when we meet at 1:30 tomorrow, or what? Because we don't need to spin our wheels if the offer expires when Mr. Chalmers leaves here today.
I think it would be our preference to take the plea tomorrow.
Okay.
If we're able to do it.
All right, and that plea would encompass a non-negotiated plea.
Yes.
Okay, so Mr. Chalmers, I think things are unchanged from when you and I last spoke. The state right now is going to be recommending 20 years to serve. Mr. Partridge shared with me that there may be something that would change that would make the state interested in recommending less. And you and Mr. Partridge have been talking about that. That's on you and not on anyone else. But for now, I understand that the state's recommendation will be 20, and Mr. Partridge will be arguing on your behalf for a time served. Leaves a lot of space in between, and the state's leaving that opportunity open through our reconnecting at 1:30 tomorrow in this same space. Between now and then, you need to figure out how to talk to the folks you want to talk to and think through with Mr. Partridge whether you're going to take steps that might cause the state to say, well, given this other situation, we're recommending less. They're not obligated to do that, and you're obviously not obligated to do anything to sweeten the pot for them, but that could be out there, and we'll see where that plays out. And the final reminder, I'm not bound by any of it. I don't get to reduce charges. So if the state reduces murder to voluntary, that creates a ceiling of that 20 years. So I can't go above that. But just because Mr. Partridge is trying to tug me down to time served doesn't mean that I have to or that I will, but I could. And certainly it's the only chance you've got of arguing for something less than life would be through this format. If you're found not guilty at trial, you don't have to argue for anything. But if you are found guilty at trial, we sort of have this reverse situation. By reducing the charges, the state can't go higher than 20. And so they're basically saying, we think 20. If we flip it around and you're found guilty at trial, the floor is life. And so Mr. Partridge could very eloquently share with me the reasons why you being out to be able to get medical care and be with family make a ton of sense. But the legislature has put that floor of life, and I couldn't go below it even if I thought there was a real compelling argument. Do you feel like you understand your options right now?
I don't understand. I just want to see do the plea come with any probation?
Say that last part. Does the plea come with probation?
Yeah, like you said, 20 years to serve, like 20 on paper. I mean, I was saying like.
Got it. Good. I think I understand your question. The state's recommendation, as I understand it, is 20 years to serve. Now, those are parolable. I'm not aware of there being a recidivist notice filed. And so what the state would be recommending is 20 years in custody, but that's a parolable 20. And Mr. Partridge can talk to you about what the math would look like. It would not be 20 to the door. It would be less than that because you would be parole, unless you, while you're in prison, do stupid things. You would definitely be parolable, but they're not talking probation. Now, I'm free to do whatever. I could give you 1 year probation for voluntary manslaughter. I don't want to get your hopes up. I don't see that being a realistic sentence, but voluntary manslaughter is 1 to 20, and it can be probated, suspended, or it can be served. And the state is recommending to me 20 to serve. And so if you get out before 20, it's parole. That's not me. That's not the state. That's parole sorting that out. What I heard Mr. Partridge previewing, and I appreciate the preview, is that he'll be arguing for time served. I might give you some probation, so it's not just you get out and there's no sentence. But if I were to go along with Mr. Partridge's sentence, and I'm not saying I am, I don't want you to leave here thinking, hey, the judge is down with that. But just making numbers up, I might do 8 serve 3, reduced to time. I don't know how long you've been in, but 8 serve 3, reduce the 3 to time served, balance probated. So you might have 5 years probation. I don't see where a case where someone was shot and killed saying, you're done, you go home. I would likely put probation in there if I'm gonna go with something less than what the state says. Okay? Did that answer your question? Anything else? You feel like you understand what I don't want to have happen is that you come back here 1:30 tomorrow and like, I don't know what we're talking about. You know what we're talking
I
about.
understand.
Okay. You talk with family, you talk with Mr. Partridge, and we will see you and Mr. Partridge and someone from the DA's office at 1:30 tomorrow. And it'll be real quick. I'm just gonna be saying, we're doing a plea or not? Not a, like, well, I need to think about more or less. You will have already thought about it. And you'll say it's a plea and we know the parameters. It fit just this 20 unless something changes the state's mind and they come down a little bit. And then I know what Mr. but then we'll have that conversation. Mr. Rao, you had mentioned that the family of the deceased wants to be heard, which they will be, and they're entitled to be. If you get word from Mr. Partridge that it is a plea tomorrow at 1:30, would we be able to make that happen, even if the family's zooming in? Or would we be taking the plea as in Mr. Chalmers enters the guilty plea and I accept it, but we defer sentencing for a week so that family can be here in person?
Ideally, it would be the first option, but I'm just thinking the way things have progressed with our conversations with them, no problem, be the latter.
Okay.
That's possible.
It is, no, I want to accommodate them, especially given you sharing with me that they're going to come in unhappy with something less than life. And they're entitled to be unhappy and they don't dictate what you do. You look at all of the variables in a complicated case. But if you conclude or the victim advocate concludes that it is better for them to be heard in person, then we'll just break it into 2 pieces. We'll lock in the guilty plea. So Mr. Chalmers knows I'm not going to trial, but I also have locked in this commitment from the state that the ceiling is right here. Okay. All right. We'll see what happens at 1:30 tomorrow. Same place. Thank you, everyone. I'm assuming you can be here. I was sort of acting like Partridge would beam in.
I'll be here early to have a conversation prior to 1:30.
Okay.
But yeah, absolutely, we'll be here.
Sounds good.
Yes, sir.
Thank you, everyone.
Thank you. And I'll email report the information for the Malone case, just in case as well.
Good. Please do.
Yes, sir. Will do. Thank you. That concludes. We're happy.
You may, and Mr. Rao, you may as well. I think that covers it for today. Let me see what else we've got. Nothing in this courtroom, so I can shut down the Zoom. Thank you, everyone.
Yes, sir. Thank you, Judge.
Judge, do you have a Takai key potentially if you know coming to court tomorrow or in court tomorrow, defendant?
I know exactly who that is, and I will look on tomorrow's calendar.
Yes, we do.
We do. Okay. Good thing I hadn't closed out the Zoom. Is that now yours?
No, I'm all over the place in the office, so
Yeah.
one of my responsibilities is supervise 5 courtrooms, this being one of them.
All right.
And it's my understanding that, I was trying to see if that case was on the calendar tomorrow. I couldn't see.
So it's plural? He has cases?
He has at least one more open indicted case for a case that he picked up while out on bond for,
And I think that's the main reason why the case is really on the calendar is because he has some co-defendants that are being arraigned.
right.
Yeah. So he and one other guy, blanking on the last name, had a case together with me. Mr. Muse?
That's
Yeah, they had a case. The weird thing with Mr. Key is he had no bond. It was a direct indictment and he never had a bond. And I was working with his lawyer. Hey, you need to get a bond. This isn't working. And then he picked up a case with a big old gun and he now has no bond and won't be getting it. I told his lawyer that, but I think he may have a 3rd case now too. And one of the cases is like 5 defendants, one of whom is Muse. So it was Key and Muse and they're like this bad Velcro ball and are bringing more cases here, but any more cases he brings would be because of something that happens in the jail, because that's where he is. And so I will see him tomorrow. But Muse, the other little piece, Muse, who was also out on bond, got shot literally like 15, 16 times, survived, but now is also in custody for having, while on bond, picked up new charges.
Is that an afternoon calendar or a morning calendar?
It's afternoon. It's 1:30. So when we're dealing with Partridge, it's Key and Muse and their associates.
Trying to avoid this office, but I guess that won't be.
Super. Okay. That'll be good for all of us.
Thank you, Judge.
Yep.
The 1 o'clock is council drill.
Yes, Tank, Ms. Nix withdrew the motion. So we're done.